Good afternoon, everyone. Welcome to our panel discussion regarding the top 6 questions on legal ethics, particularly on Canons 14 to 20, lawyer and client. So I have a question for Mr. Albolote. C engages the services of Attorney D concerning various mortgage contracts entered into by her husband from whom she is separated. Fearful that her real estate properties will be foreclosed and of impending suits from sums of money against her, Attorney D advised C to give him her land titles covering her lots so he could sell them to enable her to pay her creditors. He then persuaded her to execute deeds of sale in his favor without any monetary or valuable consideration, to which C agreed on condition that he would sell the lots and from the proceeds pay her creditors. Later on, C came to know that Attorney D did not sell her lots but instead paid her creditors with his own funds and had her land titles registered in his name. Did Attorney D violate the Code of Professional Responsibility?
The decision of the Supreme Court in the case of Hernandez versus Go is squarely applicable to this problem. Under the same set of facts, the Supreme Court held the lawyer to have violated Canon 16 and 17 of the Code of Professional Responsibility, which provide as follows. Canon 16. A lawyer shall hold in trust all monies and properties of his client that may come into his possession. Canon 17. A lawyer owes fidelity to the cause of his client, and he shall be mindful of the trust and confidence reposed in him. The Supreme Court further held that the lawyer concerned has engaged in deceitful, dishonest, unlawful, and grossly immoral acts, which might lessen the trust and confidence reposed by the public in the fidelity, honesty, and integrity of the legal profession. Consequently, the court disbarred him.
So I have a question to Mr. Henry Lloyd. So A is accused of robbery in a complaint filed by B. A sought free legal assistance from the Public Attorney's Office or the PAO, and Attorney C was assigned to handle his case. So after reviewing the facts as stated in the complaint and as narrated by A, Attorney C is convinced that A is guilty.
Well, Attorney C, as a member of the Public Attorney's Office, cannot refuse to handle the defense of A, who is an indigent client based on his belief alone that A is guilty. As Attorney C was appointed as counsel for the defendant, he is duty bound to exert his best effort and professional ability to defend his client, as stated under Rule 14.01 of the Code of Professional Responsibility. It states that a lawyer shall not decline to represent a client because of his own opinion regarding the guilt of said person. Furthermore, he cannot decline the appointment as counsel de officio, as stated again on Rule 14.02 of the Code of Professional Responsibility, which provides that a lawyer shall not decline except for serious and sufficient cause an appointment as counsel de officio or as amicus curiae, or a request from the Integrated Bar of the Philippines of any of its chapters for rendition of free legal aid. That would be all.
The next question would be for Ms. Hilario. This is a bar question in legal ethics. So the question is, Pedro was accused of the crime of murder before the regional trial court and was found guilty of homicide. His counsel, Attorney Nestor, told him that he will file an appeal before the Court of Appeals, because he believes that the claim of self-defense of Pedro will be given merit by the appellate court and that he will be acquitted. Pedro explains that he is amenable to the penalty imposed upon him. The accused, Attorney Nestor, went on the appeal. It decided that the conviction should be murder in view of the disqualifying circumstance. A petition with the High Court proved futile. Pedro hires you to file a disbarment suit against Attorney Nestor. What canon or rule of the Code of Professional Responsibility will you use as grounds for the suit? Explain.
Okay, ma'am, thank you for the question. I will base my action on Canon 19, particularly Rule 19.03 of the Code of Professional Responsibility, which provides that a lawyer shall not allow the client to dictate the procedure in handling the case. The other side of the coin of this rule is that the substantive aspects of the case are within the sole authority of the client to decide. The lawyer's authority is limited only to the procedural aspects of the case. Certainly, the matter of whether or not to appeal an adverse decision is a substantive matter which is exclusively for the client to decide. Having filed an appeal against the decision of his client, the lawyer should be held liable for its negative result. So for the next question po, I have a question for Ms. Likigan. May a lawyer collect fees for services rendered to his client despite the absence of an agreement to pay attorney's fees?
Yes. A lawyer may collect service fees for services rendered to his client despite the absence of an agreement to pay attorney's fees. It is on the basis of merit, but such doctrine may be tempered by the court if it is unconscionable. The doctrine of quantum meruit simply explains that a person is allowed to recover the reasonable value of services rendered despite the lack of a written contract. The measure of recovery under the principle should relate to the reasonable value of the services he performed.
Okay, so follow-up question, ma'am. So in the absence of a contract for the payment of attorney's fees, what factors may be considered in fixing the amount of attorney's fees?
Okay. Under Canon 20.01 of the CPR, the following factors are considered: the time spent and extent of the services rendered or required, the novelty and difficulty of questions involved, the importance of the subject matter, the skills demanded, the probability of losing other employment as a result of the acceptance of the preferred case, the customary charges for similar services and schedule of fees of the IBP chapter which he belongs, the amount involved in the controversy and benefits resulting from the client from the service, the contingency and certainty of compensation, the charter of employment, whether occasional or established, and lastly, the professional standing of the lawyer.
Okay, so I have a question for Ms. Mendoza. Brando and Luzon Law Office had a retainer agreement with Gregory, a businessman with shady connections. Gregory was recently charged in the RTC in Manila with money laundering in relation to an illegal drug syndicate using Cable Corporation, his holding company, as its money laundering conduit. The members of the Brando and Luzon Law Office assigned to handle Gregory's account, including yourself, were implicated in the money laundering case for their role in the incorporation of Cable Co. and in the active management of its business affair. In a bid to fortify the case against Gregory and the others, the public prosecutor approaches you as the least guilty person who will qualify for the discharge as a state witness and offers you to make you a state witness. Should you accept the offer? Explain your answer.
No, The information acquired involving the criminal case against Gregory is covered by the Privileged Communication Rule. So under Rule 15.02 of the Code of Professional Responsibility, it provides that a lawyer shall be bound by the rule on privileged communication in respect of matters disclosed to him by a prospective client. So there being a lawyer-client relationship between the parties, the lawyer cannot serve as a state witness and disclose the information obtained from his client.
Well, under the same facts of the preceding question, assume that you have resigned from Brando and Luzon Law Office prior to the filing of the money laundering case against Gregory and the others, and that you were not implicated in the case. However, you had assisted in handling the Cobraco account during your time in the law firm. Cobraco was largely owned by Cableco. The public prosecutor handling the case against Gregory and the other asked you as a former member of Brando and Luzon Law Office to help strengthen the case for the government and hints that you may be implicated in the case if you do not cooperate. What is your legal and ethical course of action? Explain your answer again.
So I will decline to testify against the defendants and to provide evidence in the case as the attorney-client privilege lasts even beyond the termination of the relationship. So the duty of a lawyer to preserve his client's secrets and confidence outlasts the termination of the attorney-client relationship and continues even after the death of the client. This is found in the case of Mercado versus Vitrolio.
Question for Ms. Osnal. Christine was appointed counsel de officio for Zuma, who was accused of raping his own daughter. Zuma pleaded not guilty, but thereafter privately admitted to Christine that he did commit the crime charged. Can Christine disclose the admission of Zuma to the court? Why or why not?
Okay, so Christine cannot disclose Zuma's admission to the court. Canon 21, Rule 21.02 of the Code of Professional Responsibility provides that a lawyer shall not, to the disadvantage of his client, use information acquired in the course of employment, nor shall he use the same to his own advantage or that of a third person unless the client, with full knowledge of the circumstances, consents thereto. Christine cannot disclose the admission without violating the above-mentioned canon. The information disclosed is in the nature of privileged communication. Hence, she cannot disclose it to the court without Zuma's consent. Also, even though the client admitted that he is guilty of the crime charge, still Christine cannot withdraw from the case because he will violate the Canon 22 of the Code of Professional Responsibility. A counsel can withdraw his services only for a good cause and upon notice appropriate to the circumstances. Also, whether or not a lawyer has a valid cause to withdraw from a case, he cannot just do so and leave the client in the cold unprotected. He must serve a copy of his petition upon the client and the adverse party. He should moreover present his petition well in advance of the trial of the action to enable the client to secure the services of another lawyer. Okay, so that's all for our panel discussion. Thank you for your active participation.